Yes, my lord, may I be may I, my lord, one bail in connection with appeal, another one is appeal hearing.
Bail in connection. My lord, may I be permitted to mention one matter, bail in connection with appeal?
My lord, inclusion in the daily list, my lord.
As what?
Cancellation of anticipatory bail.
All the list.
But in this matter, I am appearing on behalf of the appellant petitioner. No, I am appearing on behalf of the petitioner respondent. Lord, the order of my lord not having been complied with, contempt has been filed. The contempt was, my lord, pending since long because the records were not available. In the meantime, my lord, the contempt application substitution is required because the original petitioner died. And I have come with an application for substitution along with the section 5 because there is some delay in the first matter. My lord, if your lordship kindly see the first matter, that is in the matter of
Where are the reconstructed application?
right. We have submitted, my lord.
Department has produced the reconstructed records.
We have already submitted all the required documents.
কোথায় record to?
এটা কি সেকশন 5 সেকশন 5 নেই
Section 5.
এটা নাম্বারটা লেখ কেন এটা ঠিক আছে তো
What were the orders passed in the earlier applications?
Lord, I have annexed in the contempt application the main order. Lord, if your lordship kindly come to page number, it starts from Lord
In the
page number
contempt application, what order was passed?
in the Matt Miller at page 57 starts.
MAT file is there. MAT file is available.
Yes. And in the contempt application, we have annexed the order of the Matt.
What order was passed originally in the
Lord,
contempt application?
my lord, your lordship kindly take up the contempt application at page 57.
Reconstructed.
Madam, Matt, FMA 2233.
No, contempt, sir. 1925.
Madam, in connection of FMA 2233 of 2013, can CPN 1975. CPN 1975 of 2013.
This.
My lord, তারপরে তো আপিলটা ডিসমিস হয়ে যাচ্ছে
হ্যাঁ আপিল ডিসপোজ অফ
ডিসপোজ অফ না ডিসমিস ক্যালকুলেটর অর্ডারটা কোনটা ক্যালকুলেটর অর্ডারটা কোথায় আছে এটা বলে দিচ্ছে না রিভোক করতে বলেছে রিভোকেশনটা যেহেতু
Yes, pursuant to our orders, there was a notice given for fresh hearing.
Yes.
Then what happened?
কোন হিয়ারিং হয়েছে
No, nothing has yet been given, no hearing, no notice, further notice has been given.
21.
17 হিয়ারিং এর নোটিস দিয়েছে
After that was challenged in the Reed court passed an order. After that, nothing has been done. Then appeal appeal disposed of, not, thereafter nothing. Till that nothing has been done. Page 17.
71.
Now, Mr. A, our query to you is, you have reconstructed the records.
Yes.
Were there earlier orders passed in the contempt applications? What were the earlier orders passed in the contempt application?
Well, so far my knowledge goes, it was filed, it was not taken. Thereafter,
How do we know?
I was all along appearing in the matter. So
Where
it
appeared?
was never taken. It was never taken by the
Get a
court.
report from the CIS of the court as to whether orders were passed on these contempt applications.
Well, so far my knowledge goes,
Yes,
no
we
order
understand your
has
knowledge.
ever been passed.
We will get a report. Contempt applications have been reconstructed. Mr. Manna prays for substitution of the applicant, of the petitioner, Noni Gopal Shamanto, in CPAN 1975 of 2013. Copy of the substitution application along with the application for condonation of delay be served upon the respondent alleged condemners. Affidavit of service be filed. Though records have been reconstructed, it is unclear whether orders were passed earlier on the contempt applications. Registrar IT shall submit report whether orders had been passed
আমাদের copy service করতে বললো?
on the contempt applications being CPAN number so and so, so and so, so and so, so and so. And if so,
Miller,
orders.
can I assist Miller? One S Chatterjee is appearing in the matter.
We don't know. Serve upon the office of respondents and the office of the ASG. Copies of the orders be placed before this court. Service shall be made upon the respondent alleged condemners as well as the office of the ASG. Matter will appear 2 weeks hence.
Well, one thing is required. The present incumbent has come. The earlier condemner has retired or transferred, but the present incumbent has come. So let me permit to add him as a
Liberty is granted to add the present incumbents as respondent alleged.
and I will effect service on him.
And service be also effected on the added respondents. Necessary amendment be carried out in the course of the day.
In other two,
Same.
in other two, section 5 is there. Section 5 is the delay for substitution is there.
We have said delay as well as the application
Lord, I could not-
served.
I could not hear.
Is served. But we want to find out from the
Yes.
CIS database whether orders are there with regard to this contempt
To
proceeding.
ascertain my veracity before this court.
Records be produced with regard to orders.
Miller, my lord is not fixing the date.
2 weeks.
2 weeks.
গুলোতে substitute
In this modification application, if your lordship kindly see paragraph 10, lordship. Actually, appellant is suffered.
My lord, I am for the state, my lord, I am led by Miss Rajoshrita, my lord. I am praying for 1 day accommodation, my lord. He is unable to present today.
I beseech your lordship that appellant is suffering from lower respiratory tract infection, global hyspocomia, and kidney disease. Lordship, I have annexed the medical documents.
For what?
So I am seeking for a medical report from the
For why?
Mednipur Correctional Home.
We have disposed of the appeal.
Lordship, modification application, that's why.
We have disposed of the appeal. What are you saying?
So I know it's.
To advise your client to file this application. We should request you to have a training and your name to be deleted from the councils in the central government panel. If this is your knowledge of law, you shouldn't be in a panel. The appeal has been disposed of on merits. Application for modification of the judgment and order is without jurisdiction and dismissed.
Made please, Lordship. 498A, 304B, 302. I am the father-in-law. On the last occasion, my lord, I submitted before your lordship that I used to reside separately from the house of the,
But same what? They are deciding.
but different house.
So what?
Different house.
We have considered the materials. Petitioner contents. He is the father-in-law of the
100 meters, around 2 kilometers away. I reside.
2 kilometers.
Around.
Same locality, 2 kilometers. You are residing in Sahara Desert.
No, my lord, kindly see, my
Huh?
lord. But I believe, my lord,
Yes,
I
we
will-
believe
100
that
meters
in
away.
state of West Bengal, a locality, 2 houses cannot be separated by 2 kilometers.
My lord, kindly.
We believe that. If you want to make us believe otherwise, you have to put clear, cogent evidence in support of
Around
your
100 meters, my lord, I submitted.
2 kilometer থেকে আবার 100 মিটার কেন?
100 meters around, which is 2 kilometers.
2 kilometers is 100 meters.
Around.
কতবার?
Why are you making
লোকাল ইনভেস্টিগেশন
yourself into a laughing stock? Petitioner submit that he is the father-in-law of the deceased lady. He is residing separately and did not play any role in the matrimonial life of the couple. He prays for anticipatory bail. In light of the aforesaid submission, report is placed on record. We called for report with regard to the residence of the petitioner. Report shows that petitioner is residing in the same locality, was residing in the petitioner, though residing in another house. The said house is situated in the same locality as the residence as that of the couple. Full stop. The distance between the two houses is 100 meters. Full stop. We have considered the materials on record. Statements show petitioner tortured the petitioner, that is the father-in-law, tortured the victim lady on demands of dowry. She committed, as a result, she committed suicide within 2 years of marriage. Huh? Within 2 years of marriage. His role in the torture is more predominant than the brother-in-law, Sudip Kaur alias Chanchol Kaur, who has been granted pre-arrest bail. The petitioner's residence is almost adjacent to the house where the couple resided. This probabilizes his access to the victim. This probabilizes the prosecution case that he played active role in the torture of the victim over demands of dowry. Under such circumstances, we are not inclined to grant answer. Today, you have seen one judgment of the Supreme Court on granting of bail in dowry cases. Please check out.
326, 307. Now blood 322, 118,
Madam, for the
1091. The parties are
for the
blood
defect of complaint,
litigating before the civil court.
but
Civil court
pursuant to the
passes.
order of the court, madam,
बोले नहीं,
I'm repairing my
let him-
house. At that time, they have, madam, pursuant to order of the jurisdiction of civil court, I'm repairing my house. at that point, they are the neighbors. At that point, they have attacked me and brutally, Lordship.
Case counter,
Kind- there's no counter.
Petitioner contends that there is a civil dispute and civil suit is pending between parties. He has been falsely implicated. He prays for bail. Learned lawyer for state opposed the prayer. Learned lawyer for de facto complainant submit. He was repairing his house in terms of the court's order. At that time, petitioner and others assaulted him and his associates. We
Assaulted
have
her. Assaulted her.
assaulted her and her associates. We have considered the materials on record. There, a civil suit is pending by and between the parties. It is contended de facto complainant was making repairs pursuant in terms of the court order. At that petitioners,
Petitioners, three
as
petitioners.
petitioners, only three or there are others
No,
also?
there are only three.
Petitioners attacked the de facto complainant and assaulted her. Full stop. However,
Fact to complain and her husband, my lord. Two persons.
assaulted her and her husband.
Next page is the
CT scan report.
CT scan is not
But it's me. Report is with me.
Let us see the CT.
not in the case diary.
We have considered the injury report.
Well, 5 stitches in forehead, my lord, and 4 in backside.
All right, we have considered the injury report, including the CT scan report. Injuries, this injury report shows blunt injury, full stop. No intracranial injury is noted in the CT scan. Under such circumstances, we are of the opinion, though custodial interrogation may not be necessary, movements of the petitioners required to be restricted in order to ensure that the court order is in order to ensure the de facto complainant is able to make repairs in terms of the court order without interference.
Permission has also been given to ask for repair also.
So
Stand in the page.
you repair after the repair.
Because my FIR is after their FIR.
Not to enter the jurisdiction for 3 months.
There are 2 ladies and 1 blood.
For 3 months. That's why we have kept it at 3 months. In the meantime, you make your report. Then they will make their and you will move out.
But my application there also will be coming for anticipatory.
We will keep the
Same of license.
both will make repairs in the absence of the other. Next,
My lord,
Tanya.
item number 10, my lord, I am for the petitioner. My lord, in this matter, my lord, the de facto complainant one Ruby Lochon Pan had duped the petitioner of 3 lakh rupees in the name of a tender. Thereafter ransacked his house. My lord, thereafter we initiated a complaint.
Prosecutor, what is the
There are 2 more cases, my lord.
exposure?
2 more cases, my lord. Of similar nature.
After getting
One is of 22, one is of 24, and another is of 25.
He is on bail in these cases.
As far as one is concerned, both the other, was 2 and 3 is concerned. Your number কত রে?
Is he on bail in those two cases?
First one I know, second one don't have any idea. The third is before your lord.
No, 2022 case, he's on bail. 24 case, you are not sure.
He is before your lordship. 25 I don't.
Oh, 24, he is before us.
Before.
25, you don't. Oh, 25 again, there is another.
May I indicate few things? My lord, on 2024, my lord, 3 lakh rupees due from me. My shop was ransacked.
Which
There,
one?
my lord, thereafter, my wife registered a case. My lord, we'll get that FIR on page 14. My lord, after the de facto complainant gets bail, my lord, on 16/12/2024, anticipatory bail, 3 days thereafter, this case is registered. My lord, alleging an incident of 1 year ago, that is 29/12/2023. The allegation is that from the de facto complainant, his wife had obtained a loan of rupees 1 crore. My lord, that amount gets credited in the account of Sanjoy Pan.
You are siphoned.
No, that Sanjoy Pan, it gets credited in the account of Sanjoy Pan. That is the allegation 1 year ago. And thereafter, my lord, from Sanjoy Pan's account, it gets to the account of one Abhijit Mojumdar. They have given no objection in respect of bail prayer of that Abhijit Mojumdar. I have that order sheet. They have affidavit that we are not pursuing that. Not a single penny has been credited in my account. On the contrary, my lord, there is a seizure, particularly that 3 lakh
From Abhijit, the amount goes where?
from the entire amount gets transferred to Sanjoy Pan's account.
Correct.
One.
From there, it was sent to Abhijit.
My lord, thereafter they have not.
What happened to the amount from Abhijit's?
My lord, I don't know because I got that from the order sheets where Abhijit
Okay.
Mojumdar.
According to you, no money
Yes.
moved to your account.
Yes, and on the contrary, 3 lakh has been due from me. That is seizure from their possession.
That is.
But the petitioner camouflaged himself as a member of the banking system. He assured that he would arrange disbursal of loan to my wife. 99 lakhs rupees was disbursed to my wife. Thereafter, he forged the instrument of transfer. Instead of transferring the amount to my account, the account went to the account of Sanjoy Pan. From Sanjoy Pan's account, the petitioner squared off his debts with Abhijit Mojumdar. Kindly sees these documents. So the petitioner owed debts worth 1.5 crores to Abhijit Mojumdar. Sanjoy Pan used the funds to square off the debts of the petitioner, and thereby Sanjoy Pan became a partner in the partnership of the petitioner, which is Oishani Agro Industries.
So Abhijit Mojumdar's liability was there against the petitioner.
No, petitioner owed to Abhijit Mojumdar.
That is it. And this money was used to
square off the petitioner's debts to Abhijit Mojumdar. The petitioner cleverly did not take the money in his own account. He took it in the account of Sanjoy Pan and thereafter used Sanjoy Pan to pay off his debts to Abhijit Mojumdar.
But has the money been frozen in Abhijit's account?
Yes.
It is some part of the amount, is also there in this petitioner's account, because it is circuitously flowed back to the petitioner.
Not a single penny.
No. You have to show that there was a flow of account from Abhijit to the petitioner.
And my lord, defied after 1 year.
Petitioner submits that there was a financial transaction. Petitioner submits that he had no role to play in the financial transaction involving the de facto complainant and one Sanjoy Pan. Full stop. No, Sanjoy Pan. In the FIR, de facto complainant had alleged that the loan purportedly advanced in his name had been
in his wife's name.
Had been credited in Sanjoy Pan's account and thereafter siphoned away through the account of Abhijit Mojumdar. No money trail to the petitioner's account has been revealed. Accordingly, he prays for anticipatory bail. Learned public prosecutor opposes the prayer. He contends petitioner has criminal antecedents of similar nature. Cases, he has been implicated in cases of cheating in 2022 as well as 2025. Full stop. Learned lawyer for de facto complainant submit. Petitioner is the principal player in the conspiracy. He had posed as a financial consultant and induced the de facto complainant to take a loan, which was credited in the account of one Sanjoy Pan instead of the de facto complainant.
But the account,
It was credited in the account of the wife.
credited to my wife's
So
account.
wife's account.
Thereafter, they forged instruments and transferred the loan from my wife's account to
which was fraudulently transferred to the account of Sanjoy Pan. Full stop. Petitioner utilized the money to square off his liabilities with one Abhijit Majumdar. We have considered the materials on record. A loan in 2023, in December 2023, a loan had been advanced to de facto complainant's wife. The loan was credited to her account. Thereafter, the amount was transferred in the name of to one Sanjoy Pan, and thereafter to the account of Abhijit Majumdar. The said transfers where the movement of the money was through bank transfers, through bank transfers. Though de facto complainant contends that the transfers were fraudulent, comma, the nothing is placed on record to show that the petitioner had colluded with bank officials to make fraudulent bank transfers. Be that as it may, that apart, no money trail to the account of the petitioner is also traceable. Money in the account of Abhijit Majumdar has been frozen. Under such circumstances, custodial frozen. The other cases pending against the petitioner, though involving allegations of cheating, do not relate to the same parties or partake similar activity, similar mode, though involving allegations of cheating and fraud to the same parties or partake the same modus operandi as alleged in the FIR. They are independent transactions. They are independent events in respect of which it is open to the petitioner to seek appropriate remedy. It is open to the investigating agency to take appropriate steps against the petitioner in accordance with law. Keeping in mind the aforesaid facts, we are of the opinion petitioner may be granted anticipatory bail subject to conditions. Meet investigating officer once in a week.
Much obliged. Much obliged.
Circular transaction. Cash ka transaction. How do you say bank transfers are good? Clear transfer, not cash transfer. Have understood cash transfer? Bank transfer. Fraudulent कैसे तब तो बैंक ऑफिशियल से उसका है यस भैया उसका है कैश उसका नाम
Lord, your lordship has called for the antecedent, Lord, of the petitioner, because this is a allegation of 305A and 305E.
305A and B.
379. Well, since
Oh, 305.
lordship has called for the antecedent, whether I have any antecedent or not. No 41 notice has been given.
We have considered the materials on record. The gas cylinders have been seized. Report shows petitioner has no criminal antecedents. Under such circumstances, we are inclined to grant anticipatory bail. Petitioner shall meet investigating officer once in a week on
Obliged.
hotel business के लिए छूट.
আমার নিজেরই মনে হচ্ছে
Domestic.
Lordship, I am appealing for the petition and may I please your lordship. Lordship, allegations are under section 120B, 498B, 489C. Lordship, allegedly 297 counterfeits of amounting 500, totaling to 1,48,500 was recovered from my house.
Then, from your house,
My house, Lordship.
we have considered the materials on record. Statements of BSF personnel show. Statement of BSF personnel and seizure memorandum show recovery of fake Indian currency notes from
Petitioner's house.
petitioner's house. Petitioner has, under these circumstances, we are of the opinion custodial interrogation for keeping in view of the nature of crime.
Charges submitted.
We are of the opinion petitioner absconded and was not available for interrogation. In view of the nature of crime, we are of the opinion custodial interrogation during further investigation may lead to recovery of
Others.
may lead to further recoveries. Hence, we are not inclined to grant. Thanks. Next.
My lord, I am for the petition in this matter. My lord, the case is under section 406, 420, 506 of the Indian Penal Code, corresponding to section 316, 318, and 351 of the BNS, lordship. Now, what has happened, lordship, here, the petitioner was abducted. On 5th of January, he was kidnapped, and one of the alleged accused in that particular case, she has lodged this complaint on 6th of January at afternoon. Petitioner's complaint was lodged at 5th of January at 6th of January at 12th night before Dr. Pukur police station. Now, lordship, what has happened? Lordship, kindly come to page 36. This is the your lordship's order passed in the matter of the de facto complainant who moved an application under 438 of the criminal procedure before your lordship's court. Lordship, kindly come. Here, your lordships were given an impression that this complaint was subsequently lodged in the first paragraph. However, I am not on that, lordship. My point is that whatever allegations is been made, that I am the owner of a company, I am director of the company, and I have any stake in those companies, lordship, I have nothing to say. I am not the director of the company. Directors are other people who I have given the document. Shareholders are different. I am no way connected. Though it is admitted position, I had some monetary transaction, and lordship, in their bail application only, lordship, kindly come to page 68. My lord.
Order passed in their application.
Lordship, it's in page 36. Your lordship's order. Your lordship was pleased to enlarge her on anticipatory bail. Paragraph 3 is the mainly our case against me, which has been reflected. I have no connection with any of these companies.
Abduction के तीन कस्टडी
Total is 35 lakhs.
My lord, total amount is 35 lakhs or not? 35 lakhs? 8,028. Now, my lord, on two occasions, notice under section 179 of the BNSS was served in the month of January and February. He is not cooperating.
Lordship, I went there. They have not complied, Lordship.
My lord, 164 statement of the mother of the de facto complainant, my lord, is at 169. My lord, since it's the nascent stage of investigation, some bank documents have been obtained. Rest are yet to be ascertained, my lord. There have been transactions between the mother and we find one Deepak, who's, all of them are absconding, my lord.
Lordship,
And they are not,
The money.
my lord, so far as the present petitioner is concerned, my lord, bank documents reflecting that is yet to be received. So far as the
No,
Deepak Ganguly, his bank documents are there that mother has transferred huge amounts to his account at the behest of the present petitioner. That bank document is still.
He invested in zero debit,
Yes.
not into the personal accounts of the petitioner.
No.
Then
Lordship, the allegation is that I introduced her with zero debit and others. And that is the content of the written complaint. And their own application, these documents were annexed that I was making the part payment for the money which I took, that is almost 1 lakh, which is annexed in page 68 of the application. It is their document, Lordships. Their application I have annexed.
so far as petitioner is concerned, the amounts paid is around 5,50,000.
Around 5,50,000.
And
That is-
Deepak Ganguly, the amount paid was same, 5,50,000. And the remainder amounts are paid in the company.
The company.
The company, that is a matter to be dealt with regard to the affairs of the company. Petitioner submit that the de facto complainant and her mother had made investments
Mother, Lordship.
in a company, namely the Zeradopit. Petitioner is no way connected with the affairs of the said company. Allegation that he had taken a loan from the de facto complainant and he has made part payment in respect of the loan. He was abducted, part payment of the loan. De facto complainant and her associates had wrongfully detained him.
Would it be your lordship's pleasure to look into page 152 for a moment, the franchisee agreement between the present petitioner and lordship for a moment? Look.
We have not, this is his submission. We'll record your submission. He has been falsely, he contends that he had been abducted. He had been wrongfully detained by de facto complainant and her associates to obtain the outstanding dues. A criminal case was registered. Accordingly, he prays for anticipatory murder. Learned lawyer for the state opposes the prayer. Now tell us, what is your case?
Well, lordship kindly comes to page 152 for a moment. 152.
Yes. 152.
My lord, that's the franchisee agreement.
Correct. You entered into a franchisee agreement with Zara Dobit.
Yes.
You will give space to them.
My lord, there is some link between the company and the present petition.
From where are we getting them?
Only for such clarifications, the two notices were sent to.
So that you will clarify. Petitioners, learn a lawyer for the state submit that petitioner and co-accused Topun
My lord, co-accused is my lord Deepak Ganguly and
Deepak Ganguly had induced and Shomorjit Bagchi. Deepak Ganguly and Shomorjit Bagchi had induced the petition de facto complainant and her mother to enter into a franchisee agreement with Zara Dobit and invest money and invest money in the said company. It is also contended petitioner had induced her to hand over money on the false promise of giving placement in a private company. Full stop. We have considered the materials on record. Full stop. In the FIR, it is alleged petitioner had introduced the de facto complaint to one Shomorjit Bagchi, and she had made made to one Shomorjit Bagchi, and she made investments
in his
to the tune of 5 lakhs in the latter's business. Petitioner's de facto complainant's mother was also induced to make investments in Zara Dobit, a company with whom the de facto complainant appears to have entered into a franchisee agreement. Personal loan, loans were also, money was also advanced to the petitioner and one Deepak Ganguly. Full stop. Petitioner contends he is no way connected with the affairs of Zara Dobit. He also submits he has refunded a portion of the loan advanced to him. It appears the de facto complainant and her associates had detained the petitioner over the outstanding dues. A criminal case was registered against her. She has been granted pre-arrest bail. In this backdrop, we are of the opinion the multiple transactions entered by and between the de facto complainant and her mother with Zara Dobit and others, including the petitioner, appear to partake speculative investments and appear to partake speculative investments in ordinary course of business. It is accordingly we are inclined to grant anticipatory bail to the petitioner subject to condition he shall meet the investigating officer once in a week until trial.
Grateful, my lord.
The petitioner, my lord. My lord, co-accused persons on the same footing have been granted bail. My lord, page 19 of my application and page 21. My lord,
it is not yet come, not today. आपकी छोटा छोटा जी छोटा मोटा
My lord, 14. My lord, 14 and 15, both the matters are together.
same 16
15. 14 and 15.
61 I'm for the allegation for making preparation to commit dacoit. No incident, nothing.
we have considered the materials
Funding from 23.
very good. You have
And
considered the
this is
materials on record. No incriminating articles were seized from the petitioner. Though it is contended he had absconded for considerable period in view of the lack of evidence collected during investigation, lack of legally admissible evidence collected against him during investigation, we are inclined to grant it. Next.
Now for the applicant, this is section Malat 498 306 Malat. I'm husband Malat. You should kindly see the died declaration Malat. Actually, died declaration Malat.
Suicide note. What does she say?
Actually, she got suicide Malat rail line.
Baba ma dada dai.
আমার বর also.
And the forensic report, my lord, 96.
Petitioner is the husband of the victim lady. He contends he has been falsely implicated at the behest of the parents of the lady. He prays for anticipatory bail. And a lawyer for the state produces the case diary. We have considered the materials on record. Petitioner is the husband of the victim lady. Victim committed suicide. She left behind a suicide note exonerating the petitioner. Accordingly, we are inclined to grant anticipatory.
Diploma.
Well, I am for the petition. Well, 498A, 304B, 306. Well, principal accused is on bail. We are the father-in-law, sister-in-law, and distance relative, madam.
My lord, kindly see, my lord, Sohail Rana, my lord, I did not find his name in the charge sheet.
Yes,
One
neighbor.
Sohail Sarkar has been discharged and Sohail Rana has not been named in the charge sheet also.
The principal accused is on bail.
And my lord, PM is at page 35. Well, PM is at page 35. I find my lord, PM is not corroborated. Well, if you kindly my lord, see the PM.
Why does not corroborate?
So far, my lord, so far the carrying of baby is concerned, my lord.
Alright. Otherwise, it is.
Otherwise, my lord, otherwise it is, my lord.
Maybe.
My lord, that only that portion, my lord. Only that portion.
How many months after the marriage incident?
1.5 years.
1.5 years. Maybe there was a miscarriage or abortion.
That
because this incident occurs, she says 3 months ago.
3 months ago.
She had become pregnant.
My lord.
And this is 1 month ago. So in the meantime, the last 1 month she was residing at her parents' house. Maybe they had aborted the child. Petitioner submits. They are the in-laws of the victim.
Well, Sohail Rana, my lord, whether Sohail is accused or not, my lord, kindly see the charge sheet.
My lord, if your lordship kindly page 90.
If she is not the accused, please tell her he is not the accused. Why Shoel Rana you have made petitioner?
Well, Sohail Rana is wanted, my lord. Wanted, my lord, in this case.
Oh. He is not charge sheeted.
Then not pressing, my lord.
Petitioner number 4 has not been cited as an accused in the charge sheet. Accordingly, we are of the opinion there is no apprehension of arrest and the application preferred by him is disposed of as not pressed. Petition number 1, 2, and 3 are the in-laws of the victim lady. They contend they have been falsely implicated. They pray for Anson Tribal, and a lawyer for the state opposed the prayer. We have considered this statement of the mother of the deceased. She states victim lady was subjected to torture. Her husband disowned the unborn child. When she became pregnant, her husband disowned the paternity of the unborn child. On the day prior to the incident, there was an altercation between the husband and the deceased. Keeping in mind these facts and the extent of complicity, husband of the deceased is in custody, has been granted regular bail. Keeping in mind these facts and the extent of complicity of the petitioners in the crime, we are inclined to grant and speedy bail to them.
I'm deeply obliged.
Excellent. Event back to a parental home.
This is not complete, my lord. 90. Allegation of
is what? 64
gang
or
rape.
6?
69. 69. my lord.
69 gang rape.
70.
71.
70.
May please, Your Lordship.
Yeah, for the state, my lord.
316 2, 316 5, 318 4, 35. It is corresponding 406, 409, 420, and 34 of Indian Penal. But the petitioner is a secretary of Madrasa community. So, another two persons are there who are the superintendent and assistant superintendent of the madrasa. What we have done, 4 rooms of the madrasa were constructed and we handed over that room to another educational institution for their use. But that is the only allegation in the FIR against us, that we handed over 4 rooms to one educational institution for their own use. This is the only thing. But one person has been granted bail. Does you kindly see the last order? It is third last page. There it has been held by the learned judge. That one kindly see that last order. It is order dated 16/1/25.
These are teachers' representative.
Matter he is also signatory to the lease agreement, and it is also
All the
held-
3
it
accused
is-
persons are signatories of the lease agreement.
Yes.
At page 57. But my lord, the lease agreement did not have any approval.
Without the approval.
Yes, my lord.
Petitioner is who are you?
Secretary of the managing committee of the madrasa.
Petitioner is the secretary of the
Was my lord at
was
the
the
time.
secretary of the managing committee of the madrasa concerned. He contends he submits allegations in the FIR do not merely show that a lease agreement was executed without obtaining requisite permission. These allegations would not constitute offenses of cheating or criminal breach of trust. He co-accused a member of the managing committee has been granted anticipatory bail. He also prays for similar relief. Learned lawyer for the state submit the madrasa committee had constructed 4 classrooms using government money. These said classrooms had been let out to a private
school
institution without permission of the concerned authority. We have considered the materials on record. It is materials on record which show, we have considered the materials on record which show petitioner and other members of the madrasa committee had constructed 4 classrooms with government money. The classrooms had been 6 classrooms for government money. The classrooms had been let out to one to a private
NGO.
institution without necessary permission. No such act without permission. Full stop. There is nothing on record to show. Now, the school these rooms comprising the school building stand in the name of the madrasa. Nothing is placed on record to show that the money had been otherwise diverted or misappropriated. Whether grant sanction of
Like the building is in the name of the madrasa.
that is why we are saying that
Yes,
the
ma'am.
rooms are part of the building which is
Yes.
standing in the name. So there is no question of transfer of funds or property of government property. Whether grant of lease to a third party without permission would constitute offences under the penal code requires to be assessed at the appropriate stage of the proceeding. Appropriate stage of the proceeding, full stop. Under such circumstances, custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined to grant answer.
Deeply observed.
Thank you.
21. we have considered the materials on record. Dispute arose out of a the incident arose out of a land dispute, full stop. Injury, though on a vital part of the body, is not grievous. Under such circumstances, we are inclined to grant it.
My lord, we have the '23, my lord, on behalf of the petitioner, just praying for not today, my lord. He has a personal difficulty. The advocate has not been able to come to court, my lord. He has a car breakdown at Shodhpur. He's stuck up there. Just not today.
The victim has been notified from their end, your lordship.
Just not
He was
today.
kidnapped and thereafter 5 lakhs rupees was demanded.
Shomen Bose. Oh, acha, acha.
Intimate the victim. The victim, the officer in charge shall notify the victim 1 week.
My lord. Okay.
Under 85, 80, 103, subsection 1 and 3 and 5, 3 by 5 of the BNS. That is my lord 498A, 304B, 302, 34. Death by manual strangulation. Husband, mother-in-law is in custody, my lord. We are the Mama Shoshurs. We used to reside separately in a different village.
How much separate?
My lord, same village.
My
My
lord,
lord,
no, not same village. My lord, the Aadhaar card says, my lord, we used to stay at village Dihi Bagnan, and her matrimonial home was at Madar Chowk. I have stated that in my petition, the constitutional, page 2. We are the Mama Shoshurs.
Where do you reside?
My lord, village, my lord, Dihi Bagnan.
My lord, all of them resides in the same place.
Within the same police station, but different village.
You are Dihi Bagnan.
Yes, my lord.
And they are staying in village Madar
Madar
Chowk.
In the FIR, it has been depicted that we all stay at Madar Chowk. Principal accused is in custody, along with the mother-in-law.
My lord, PM is 123, manual strangulation. within 1.5 years of marriage.
The FIR itself, there is a statement implicating you.
It says that all of them, my lord, killed her.
Telephone. Over telephone. They got-
Just the night prior, my lord, of the incident.
He, my lord, say separately, my lord. Now, subsequent correction. Kindly, my lord. Because husband is in custody because she died inside the bedroom.
If in the person who was assaulted, it alleges that they were assaulted এবং রাত্রিরে আন্দাজ সোয়ানসো ফোন করে জানায় আমার জামাই তার মা ও তার মামারা
Yes, my lord.
আমার মেয়েকে প্রচন্ড মারধর করে
4 mama shushus are there. 2 have been arrested.
Then
2 are left, my lord, before your lordship, my lord. Omnibus allegations with respect to mama shushus. And kindly see, my lord, it has been stated in the morning at 7 o'clock in the morning.
petitioners submit that they are the maternal uncle of the deceased housewife, maternal uncle-in-law of the deceased housewife. They reside separately from the housewife. They do not reside in the matrimonial home of the housewife. They have been falsely implicated. They pray for anticipatory bail. Learned lawyer for state opposed the prayer. We have considered the materials on record. In the FIR, the deceased mother alleged on the night of the incident, the deceased had made a phone call and informed her that she was assaulted by her husband, parents-in-law, and the maternal uncles-in-law. Full stop. In that night, she committed. That night,
She was manually strangulated.
that night she suffered unnatural death. Postmortem report shows she died due to manual strangulation. In view of the aforesaid evidence on record and the cause of death being homicidal, we are of the opinion this is not a fit case to grant anticipatory bail.
My lord.
Grateful, your lordship.
Next.
I am for the petition, my lord. My lord, offense under section 329, clause 3, 117, 105, 35, Bharatiya Nyaya Samhita. My lord, on 25th February, my lord, 4
Person died.
1% died.
Then,
My lord,
so how many persons you want to die? Huh?
15%.
15%.
Yeah, my lord, kindly see order sheet, my lord, passed by lordships. 3% allow anticipatory bail, 1% rejected.
Abdul Goni was
Abdul
struck
Ghani
down.
rejected. But other 3% allowed. As per statement of injury person, my lord.
Seven and nine rejected.
Lordship,
7 and 9 rejected.
Lordship 9 and 11.
Mannan and Belal.
Lordship, no, Belal and Monirul.
We have said in the medical papers, Mannan and Belal are named.
Lordship, it is wrongly said. Lordship, kindly see.
This is not Mannan.
Lordship, Monirul is the 11. Third name, Money.
Okay.
So 9 and 11, they are standing in the same pool.
Petitioners submit that the the names of all the petitioners submit that they have been falsely implicated in the case. Allegation of collective assault by 20-25 persons is not supported by the number of injuries noted in the postmortem report. Co-accused so-and-so have been granted pre-arrest bail. They pray for similar relief. Learned lawyer for the state submit. Co-accused persons granted bail in CRM A652 of 2025. Learned lawyer for state contents in the said order granting anticipatory bail. It is incorrectly recorded that Abdul Goni, that is Abdul Goni alias Abdul Goni, Bilal Sheikh and Mannan Sheikh, inverted comma, purota, were named in the injury report, were specifically named in the injury report. In fact, the names occurring in the injury report are Abdul Goni, Bilal Sheikh and Moni alias Monirul Sheikh. Full stop. In light of the aforesaid submission, we direct order dated so and so be accordingly corrected. Full stop. And the names Bilal Sheikh and the name Mannan Sheikh occurring in the third paragraph of third line of paragraph number 3 of be read as Moni alias Monirul Sheikh. Full stop. Having considered the materials on record, we note petition number 7,
9 and 11.
Petition number 9 and 11, namely Bilal Sheikh and Moni alias Monirul Sheikh, were named as the assailants in the medical papers in the first instance. They stand on the same footing with Abdul Goni, whose prayer has been turned down. Other petitioners stand on similar footing with co-accused who have been granted anticipatory bail. Accordingly, we are inclined to grant bail to them. Other petitions, namely petition number 1 to 8 and 10. Next.
Let's say for the petition.
For the state, this is the injury report.
We fight between them over the issue of
There's a deep cut, 2.5 inch, stitches done. And he got admitted for 1 day. No specifically name, all the name has been taken, 5 petitioners. In statements, page number 43, 44, 45.
Petitioner submits there was a skirmish between the parties over a land dispute. They pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Incident occurred in the course of a skirmish which broke out between the parties. Injury report shows injury on vital part of the body, that is scalp, but the injuries are not serious, but nothing is placed on record to show that the injuries are grievous or life-threatening. Under such circumstances, we are inclined to grant answer.
That's great.
Next.
Case of 2019. There's a bomb blast injury.
We have considered the materials on record. Victim suffered bomb blast injury. Petitioners have absconded for more than 6 years Under such circumstances, we are not inclined to grant answer.
Okay.
Next.
But total 5 accused persons were there. Husband committed suicide. This was the second marriage. Wife is the principal accused. My lord, it was alleged that the wife, along with her 3 friends, killed the husband. Afterwards, my lord, while submitting charge sheet, my lord, 3 of the friends I'm sorry, my lord, 4 friends. 3 of the friends were discharged from the case, my lord, and I was made an accused along with the wife. My lord, the husband committed suicide over here. Allegation of murder.
Cause of death.
My lord, the PM kindly see the nature of injuries, my lord, in the PM. My lord, opinion has been reserved.
No.
That.
There's so much.
Kindly seize this.
What will
be served? That opinion has been reserved, my lord. Kindly seize this, my lord. The head injury was not supposed to be, my lord, was not a reason for the death.
I know. But can stun a man? Can't it? Can't it? Can't a person hit you on the head, stun you, and then hang you?
But this was a cause of suicide, suicidal in nature.
No. It's hanging.
Hanging.
So hanging would definitely be ordinarily suicidal, provided certain criteria are fulfilled. No other injury on the body.
Only non-continuous ligature.
You can always stun a man. You can always make him drink stupefying substance and then hang him. That don't make every hanging is not suicidal.
That is not the allegation, my lord, that she was giving anything stupefying.
Yeah, say the allegation is he was assaulted and killed. It's simple as that.
My lord, now the investigating agency, what they have done, my lord, have not charge sheeted 3 of the friends and only have, my lord, implicated me.
Because both of you were at the place of occurrence.
No, my lord, no such allegation is there, my lord. It is only.
This is the paramount, my lord. My lord, having some illicit relations.
Where the incident occurred?
My lord, in the house, my lord, rented house of the deceased.
In his own house, he was killed.
Yes, the wife was there along with Murtaza.
But
that is what Mr. Ganguly show us, that Murtaza was there.
My lord, from the call records, my lord, CDS, my lord, that will
call record will show what?
My lord, tower location and all, my lord, that
tower location will show he was there.
My lord, his presence was in the.
All records can show 2 things: that there is a telephonic exchange between the 2. Tower location can show ordinarily in and around that place he was there.
Yes, my lord.
What do you want to rely on?
My lord, 164 statement at page 170, my lord, kindly see.
But there is no eyewitness according to you that he was there. How do you establish that he was?
They say that both of them, the previous day, both of them, my lord, they have threatened. Well, that party is there, my lord. And so far as the 164 statement, can you see at page 170, my lord?
170. He threatened.
Threat party is there.
That is on 15th. And he died on 16th. Now, all detailed records, what does it show?
Well, all records, those conversations are, my lord, only the mobile, the phone is, my lord, incoming and outgoing, my lord, this sort of.
Does the tower location show that he was near that house?
No, my lord, tower location, even tower location is not there. Only the call details.
All details, interaction. Interaction. The thing is that
only the, my lord, PM was troubling me, my lord.
PM is
yes, my lord. That's my lord, why I.
You can just say that because it's a non-continuous ligature mark.
ফটোগ্রাফি থেকে ওকে মারতে দেখেছে, ও মারছে বসে বসে। এই লোকটা যে মারছে সাথে দেখছে কে বলো? তাহলে তুমি তাহলে কি বলবে? আমাকে তো ট্রিট ছাড়া দেখাবার আর কিছু না।
Surrender. Petitioner contends the involved तो जरूर है, but then because it's a murder, custodial interrogation is necessary. It may lead to recovery of the articles which was used for commission of murder, section 27 recovery. Petitioner contends the victim had committed suicide. He is falsely implicated in the case. He was not present at the place of occurrence. He has been falsely implicated. He prays for anticipatory bail. Learned lawyer for state opposed the prayer. We have considered the materials on record. Statements of witnesses show petitioner, he was not present. Co-accused have been granted
No,
were
Resma is in
not
custody.
not charge sheeted.
Wife is in custody.
Wife is in custody, and 3 of the other accused persons were not charge sheeted.
We filed a charge sheet.
It's a pick and choose, my lord, way they are the investigating
The
agency has.
investigation, my lord.
How did you file a charge sheet in this
Don't know,
case?
my lord.
What? How are you going
The
to?
my lord has seen, my lord, what has been collected. My lord.
How are you going to implicate him now?
Like,
What is this?
apart from threat and all, my lord.
The threat is all right. The threat is against the others also
also.
threatened. Others also threatened. How do you single him up? Is there any further statement that there was Murtaja and this?
My lord, it was, my lord, subsequently they were specific about this, that there was 4 persons.
No,
So
call
this
detail
person was having the relationship, it was established. The others
statements are,
my lord, more or less, my lord, there are statements to that.
to that effect, and CDRs are there.
Yes.
He was not present at the place of occurrence. Co-accused have been discharged from the case. He prays for answer. Learned lawyer opposes the prayer for bail. We have considered the materials on record. Petitioner had illicit relation with the deceased's wife. With the deceased wife. Full stop. He had materials have come on record to show that the petitioner and the deceased wife threatened the deceased prior to the incident. CDRs collected during investigation show telephonic conversation between the petitioner and the deceased's wife. Full stop. PM report notes lacerated injury on the head in addition to the ligature around the neck causing asphyxial death. Full stop. Asphyxial death. In light of the aforesaid circumstances, we are of the opinion there are prima facie materials to involve the petition to show that petitioner had motive to commit the crime and was in active conversation with co-accused, that is deceased wife, in prior to the murder. His role in the crime is prima facie. His role in the crime is on a much higher pedestal than the other co-accused who have been discharged. Accordingly, we are not inclined to grant anticipatory bail.
Yes.
I just charge it and say that we will go for other.
I'm going to petitioner. The section
Allegation is of 307, my lord. The injury report is on page 31, my lord.
The wife is the constable, police constable, and the petitioner is a school teacher. Well, I am for the petitioner husband. The allegation was one year ago, the wife was driven out from the husband's house. After that, the husband went to the house of the wife to make the matter settled.
Petitioner submits that there was a matrimonial discord between the parties. De facto complainant wife was residing at her matrimonial home for 1 year. He tried to persuade the wife to return to the matrimonial home. In retaliation, he has been falsely implicated with raised for anticipatory bail on a lawyer for the state opposes the prayer and contends petitioner throttled the victim wife. We have considered the materials on record. The petitioner is the husband of the victim wife. There was matrimonial discord and she was residing at her parental home. On the fateful day, it is alleged petitioner had tried to throttle. Petitioner tried to throttle her. Whereas full stop. Whereas petitioner submits that he merely persuaded her to return to the matrimonial home. The rival versions may be thrashed out at the appropriate stage of the proceeding. Injury report does not disclose external body injury on the victim and supporting the allegation of an attempt to throttle her. Accordingly, we are inclined to grant answer. Next.
But in this case, is a case of 3 and 4 of the Indian Explosive Substances Act. In this case, my lord, other two co-accused approached before this honorable court for anticipatory bail. Their prayer for anticipatory bail was turned down. My humble submission now that in the charge sheet has been submitted and the principal accused has been granted bail. On the basis of co-accused statement, my name transferred. Only against me that
We have considered the materials on record. Petitioners were involved in busting bombs. They had absconded for almost 2 years.
No, 1 year, 6 months.
Prayer for pre-arrest bail of co-accused have been turned down in CRM A 68 of 2025. Accordingly, we are not inclined to grant.
Nobody sustained injury, right?
Yes. Next.
Well, I'm filing a affidavit of service.
Time for the opposite party number 1 to 4.
My written complaint was lodged on 8th of February 2021 for torture upon wife and demand of
Time
dowry.
for the accused, my lord.
Delay, how many days?
My lord, delay, my
My lord,
lord.
there is no delay, my lord.
What is the CRAN?
My lord, I filed, I was under the impression there is delay, but after calculation, it was found that there is no delay.
CRAN not praised. Having considered the averments in the, having considered the grounds in the petition of appeal, we are of the opinion petitioner has made out an arguable case in his favor. Appeal is admitted.
My lord, divorce by mutual consent.
Issue usual
198 Calcutta.
Call for trial court records. Petition respond number so and so to so and so.
And stay of the operation.
1 to 4. What shall appear before the trial court within fortnight from date, which shall be released on bail, paper books within 6 weeks.
My lord, only one thing in this matter, my lord. My lord, there was a proceedings, my lord, before the learned court below, my lord, in
My proceeding under section 177 oblique
my lord,
182.
it was there, my lord. If the
Well,
comes over here, my lord, then there will be a difficulty in my lord. Because for false, my lord, impression, my lord, the complaint was filed. It was not proved.
All right. Call for lower court records. Trial court records. Matter will appear 2 weeks hence. Be ready. We'll hear out.
Yes, my lord. Can it be?
At best, we will set aside that court.
Well,
He is basically aggrieved by.
well, mutually, well, it has been, divorce has
He is
been.
basically aggrieved by that.
Yes, yes, that is
partner
why,
issue.
well, this
Yeah,
petition.
Yes, next matter.
Sorry. Three hundred conviction under section 304 2.
302.
300 case started under section 300.
How long you are in custody?
I'm in custody for 6 years now. 10 years punishment, 6 years.
Appellant is in custody for 6 years. That is more than half of the substantive sentence.
6 years, 5 months.
More than 6 years. That is more than half of the substantive sentence imposed on him. Paper books are not ready. Ready?
No, Lordship. No.
Though trial court records have arrived, paper books are not ready in view of the protracted period of incarceration suffered by the appellant, and as the sentence is one of term imprisonment, we are inclined to suspend the sentence. Hello.
I'm highly
Grateful for the opportunity, my lord.
Get কোথায়? Mr. Ranjan Chakravarti. Ranjan. He's in hospital. Last Friday suffered a massive heart attack. Ranjan.
চক্রবর্তী
Forty-two, my lord, I am appearing on behalf of the appellant, convicted under section 302 of the Indian Penal Code and sentenced to suffer rigorous imprisonment for life. He is in the custody for more than 3 years, 1 month. And throughout the trial, throughout the trial, he was in custody. তাই তো? তাই বলছিস তো?
The incident is of 1st August 2022.
First, 8th January 2022. And thereafter, my lord, this is 25. Total 7 prosecution witnesses. And my lord, allegation is the eyewitness, alleged eyewitness, who is PW2, he said he was coming with the de facto complainant there with the appellant. Suddenly they met with the appellant and hot altercation took place. He picked up a split of bamboo and gave a blow.
But the hot altercation is not, where is the evidence of?
Yes, PW2, my lord, this, my lord, kindly please. PW2. Kindly sees the examination in chief of PW2. After skipping 3-4 lines, from third line, one altercation took place in between Sanjoy Mujrai and Tusharkanti Singh over the issue of keeping key of that house. I was returning home with Tusharkanti Singh, and on the way, and in front of the house of Bikash Dolui, his son Akash Dolui caught hold of collar of my shirt and pushed me. Thereafter, altercation took place in between myself and Akash Dolui. Thereafter, Akash Dolui and his wife dispersed me. And thereafter, suddenly, Bikash Dolui came behind Tushar Singh and struck him on his head by wooden bottom. One piece of splitted bamboo that was seized, resulting with Tushar Kanti Singh fell down on the ground and sustained bleeding injuries. PM is my lord. PW6. PW6. On dissection, I found extra vessation of blood 9 inches into 9 inches diffused over fronto-parieto temporo-occipital region of scalp. One fissure fracture 1 inches in length present over both tables of right of temporal bone. Then subdural hemorrhage.
Hmm. Ten years.
Yes.
10 years.
10 years.
10 years করে দেবেন রাজি হয়ে যাও হ্যাঁ মাইল
থেকে 10 হচ্ছে কি?
আর কি চাই হ্যাঁ
থেকে 10 হচ্ছে আর কি হবে?
তার মধ্যে 3 বছর অলরেডি কাস্টেড
হ্যালো
We reduce it to 10 years.
Not as your lordship.
grateful my lord.
On consent of parties, appeal is taken up for hearing. Appellant has assailed judgment of order dated 25/7/2022.
বুঝিয়ে বলে দিন ওকে অনেক অনেক
There's a 50-page judgment here. Come on, proceed. ये नहीं करे. He has said that it falls on third clause of section 300. So what was the size of the bottom, etc.?
3 feet.
3 feet to 5 and 5 inches.
3 feet 5 inches. Wooden bottom he had struck on the.
Hey, what big? 3 feet 5 inches.
5 inches means like
thick-
this.
thick one. Just a rod.
On wood.
Sort of lathi.
Sort of lathi.
It is said that
The wooden
bamboo-
bottom is the.
It is said that
The word
bamboo-
used is bottom.
What is a bottom? Bottom is a log.
Block of a wood. Yes.
Block.
Block
A
of
log.
Yes.
A sort of a log.
Well, if your lordship sees PW7, it is said IO said I seized split bamboo.
All right. Judgment order dated 24/7/2024 and 25/7/2024 passed by Additional Sessions Judge First Court Klongduk in Sessions case number so and so, ST number so and so, convicting the appellant for commission of offence punishable under section 302 IPC and sentencing him to suffer rigorous imprisonment for life and pay a fine of 10,000 in default to suffer in default to suffer simply for 3 months more. Prosecution case alleged against the appellant is as follows. If I second file that is as follows. Stop.
Different notification.
father of the is as follows. One Tushar Kanti Singho, he died.
Yes.
One Tushar Kanti Singho, bracketed the deceased, was the secretary of village Uttarpulli. Village Uttarpulli of village Tikrampur. Tikarampur. full stop.
Tikarampur.
There was a long-standing dispute between Tushar on one hand and the appellant and his associates on the other. Full stop. On 8/1/2022, around 8:30 a.m., the appellant and associate and the accused, being armed with lathi, katari, and heshua, restrained Tushar while he was returning home and abused him in filthy language. Semicolon. An altercation ensued, and the accused started assaulting him with lathi, wooden batam on his head. Tushar raised hue and cry, and people arrived at the spot. Tushar raised hue and cry, and his son,
Devendra PW1. Devendra
Sinha.
Devendra Sinha, PW1, and others arrived at the spot. They took Tushar to Purbo Mednipur District Hospital, where he was declared dead. Devendra lodged written complaint resulting in Nandakumar PS case number 9 of 2022, dated 8/1/22, under section 302(34) against the appellant and
seven others.
Full stop. In conclusion of investigation, charge sheet was filed and charge was framed against the appellant and 7 others under section 302(34) of Indian Penal Code. They pleaded not guilty and claimed to be tried in courts of trial. Prosecution examined
7 witnesses.
7 witnesses and exhibited a number of documents. The defense of the appellant was one of innocence and false implication. In conclusion of trial, the trial judge, by judgment order dated so and so, convicted and sentenced the appellant as aforesaid. Other accused were acquitted of the charge. Mr. Joyanto Narayan Chatterjee, senior advocate, submit the trial judge failed to appreciate that the version narrated by PW2, the eyewitness, is at variance to the genesis of the assault narrated in FIR by PW1. Even if PW2 is believed, it appears that the incident occurred in the course of a sudden fight and the appellant did not have intention to commit murder. Accordingly, he prays for acquittal. Mr. Bhattacharya with Ms. A, on the other hand, submit PW2 is a reliable eyewitness. Appellant had hit the victim. Appellant had suddenly hit the victim with a wooden bottom, that is log, on the head. As a result, the victim died. Intention to commit murder is evident. Full stop. We have considered the evidence on record in light of the submissions made at the bar. PW1,
One thing may I just point out, my lord?
yes,
The evidence, the cross-examination of PW1, the suggestion was given, my lord, in the second page of the evidence. Suggestion was given, it is a not a fact, recorded as not a fact, that 4 number of criminal cases were lying pending in between my father and the accused persons prior to the incident. It was a suggestion that was advanced from the defense.
There was
4 criminal cases were
because there are enmity between
pending and enmity is there.
দর্শক সেটা বলেওছেন যে লং স্ট্যান্ডিং ডিসপিউট ছিল আমি সেটা
And this is the suggestion that came from the defense.
PW1 is the de facto complainant. He is a reported witness. Now, he is a reported witness. He stated his father told him that the appellant had hit him with a wooden bottom, resulting in injuries. PW2 is the sole eyewitness. He deposed
The 2 eyewitnesses, 2 and 3.
Acha, PW2 and 3 are the eyewitnesses. PW2 deposed an altercation had taken place between one Sanjoy Mujrai and Tushar over issue of keys, over issue of keys of keeping of keys of the house. On the fateful day, that is 8/1/2022, he was returning with Tushar. At that time, Akash, son of the appellant, caught hold of his collar and pushed him. An altercation ensued between him and Akash. Thereafter, suddenly Bikash came from behind. Now, when the matter thereafter, when the matter was de-escalating, when the tension was de-escalating, Bikash suddenly came from behind and hit Tushar with a wooden bottom on the head. As a result, he suffered bleeding injuries. He was taken to hospital and declared dead. PW3 corroborates PW2. He states that there was an altercation between the parties. Now, he states when she states when Tushar and PW2 were returning home, Bikash and others restrained them. There was an altercation. At that time, Bikash hit Tushar with a wooden bottom. Full stop. The aforesaid eyewitnesses find corroboration from the postmortem doctor PW6. He found the following injuries on the deceased. He opined death was due to effect of injuries, antemortem in nature. PW7 is the investigating officer. He deposed. During investigation, he had arrested the appellant. He seized split bamboo under the seizure list. He seized split bamboo. He proved the seizure list. Exhibit P2. Exhibit P2. Exhibit P2. Full stop. From the aforesaid evidence on record, Exhibit P2, full stop. However, now during trial, a wooden bottom measuring 3 feet and 5 inches into 5 inches was produced in court. Who identified it? Was produced in court. Full stop. However, was produced in court. From the aforesaid evidence on record, it appears there was long-standing quarrel between the appellant and his family members on one hand and Tushar, the deceased, on the other hand. On 8/1/2022, Tushar was proceeding. On 8/1/2022, there was on 8/1/2022, Tushar was proceeding towards his residence with Prashanto, PW2. At that time, Akash, the appellant's son, accosted Prashanto. An altercation ensued. When they were dispersing, appellant hit Tushar with a wooden bottom on the head. Full stop. With a wooden bottom on the head. PW2's version is corroborated by PW3. PM doctor, PW6, also notes death was due to injuries caused due to assault by hard substance. Full stop. In light of the evidence on record, it has been proved that in the course of altercation, the appellant had hit Tushar on the head with a wooden bottom, resulting in injuries and ultimate death. Whether the act of the appellant would constitute murder or would constitute murder or is the moot question. Trial judge disbelieved that the incident occurred in the course of a sudden quarrel and the appellant had acted in a heat of passion. He contended, he opined that the appellant and his son, he opined due to prior enmity, appellant and others had accosted the deceased and others and hit and his son had accosted the appellant and Prashanto, and the appellant had hit him with a wooden bottom on the head. Would stop. We are unable to subscribe to this view. Consistent evidence on record of the eyewitnesses, PW2 and 3, show there was a sudden quarrel show, owing to prior enmity, a sudden quarrel had erupted between the two groups. Initially, appellant's son had accosted PW2. When the when the matter was de-escalated, when they were dispersing, appellant suddenly hit Tushar on the head. It is clear that Tushar on the head. It appears now when judged Tushar on the head, resulting in bleeding injuries. Full stop. Altercation and a sudden quarrel and altercation giving rise to a fit of passion is a natural instinct. It is a natural instinct. Evidence their trial judge ignored the evidence of PW 2 and 3. That there was altercation immediately altercation between PW2 and the appellant's son at the time of the incident, which may have prompted the appellant to act in a fit of passion and hit Tushar on the head. And hit Tushar on the head. Full stop. The factual circumstances coming out from the prosecution evidence shows clearly establishes that the appellant would be entitled to the benefit of fourth exception to section 300 of the Indian Penal Code. We are also unable to accept that the strike on the head. Now, it is also pertinent to note that the injury caused on the victim will fall within the third clause of section 300 of the Indian Penal Code. PM Dr. PW6 does not opine that the injuries inflicted on the victim were sufficient in ordinary course of nature to cause death until in the absence of such opinion, it would not be correct to level every head injury caused by every head injury as to hold every head injury would attract the aforesaid clause. Not sufficient in ordinary course. May be caused by harassment, but not sufficient. It is full stop. Finally, there is another lacuna. Finally, with regard to the weapon of offense, that is wooden bottom, produced in court, we note that the description of the weapon seized, we note that the said object had not been identified by any of the eyewitnesses, but had not been identified by the eyewitnesses PW2 and 3. as the weapon of offense. PM doctor was also not shown the wooden but as the weapon of offense. On the other hand, the weapon, the article seized. On the other hand, PM doctor. On the other hand, IO PW7 opined deposed that he had seized split bamboo as the weapon of offense. In this backdrop, in these circumstances, though we have no doubt that the appellant had used a wooden log / split bamboo to assault the victim on the head, causing fatal injuries, whether the wooden bottom measuring 3 feet by 5 inches was the weapon of offense cannot be said to have been proved beyond doubt. In light of the aforesaid discussion, we are inclined to alter the conviction of the appellant from section 302 to section 304, part 1 of the Indian Penal Code. Consequentially, the sentence of the appellant is also modified. He shall suffer rigorous imprisonment for 10 years and pay a fine of rupees so and so. Appeal is disposed of.
Grateful, grateful.
Sanjana, where is your report?
My lord, the report is not yet come, my lord. Kindly give me 1 week time, my lord.
All right, we adjourn 1 week, report be filed.
And I apologize, my lord.
40-41. Your senior is busy. Why are you gossiping outside?
No, my lord, I was in 26.
There are 2 appeals filed by
cancellation.
Apply for the petition. First time appearing before Lordship, my lord. Lord cancelling 498, 307, and 312. There is an injury, it is not considered by the unled court below.
Not necessary. When was the bail granted?
The 7th of my lord, November 2023.
Any allegation of misuse? Not necessary. Appellant contends that the injuries, that the learned judge failed to consider the injuries on the victim. We note that the learned judge, we have produced the impugned order. Learned judge had considered the case diary and after
Page 15, 1-5.
considered the nature of injury and other attending circumstances and granted anticipatory bail. In November 2023, there is no allegation of misuse of liberty. Under such circumstances, we are not inclined to interfere with the order granting answer. Next.
Well, I am appearing for the petitioner.
And for the opposite parties, my lord.
Well, the case under 307, well, anticipatory bail was granted. My lord, kindly seize the impugned order. And after that, there has been consistent attempts to threaten us. We are all brothers. Well, this is a small list of dates. Showing their conduct after the grant of anticipatory bail. Supplementary kothay? And the supplementary contains the FIR, which is at page 8 of the supplementary.
Can you read the presumption of innocence of an accused till he is found guilty? Mind being fumigated with the above sanctified position of law. Let me now inspect the matter.
The fumigate.
हाँ fumigation है.
What is fumigation?
इसको तो sanitary inspector.
Mind being, yes.
Milord, charge sheet has already been filed in this matter under bailable sections.
Milord, we are on bailable.
Yes, Milord.
No, but we are on his post bail. Bailable.
No, সেটা তো
Milord, we are.
Let me come back with instruction. Charge sheet হতেই পারে না বেলে।
হ্যাঁ। কোন section?
324, 114 IPC.
324 হচ্ছে।
জানি না, but no idea.
Smarter lawyers than you.
কবেকার date?
You consider yourself to be smart.
8.
Others are smarter.
8824.
Senior advocate assails order granting anticipatory bail. He contends that the learned judge had not taken into consideration the criminal antecedents and other relevant factors. Learned lawyer for the state and de facto complaint submit that charge sheet has been filed under bailable sections in respect of bailable offences. In view of the aforesaid development, we do not find any reason to interfere. We are of the opinion the application for cancellation of anticipatory bail is unmerited.
But kindly considers his subsequent behavior.
Unmerited. It is open to with regard to post bail conduct. It is open to the petitioner to agitate his grievances before the learned magistrate in accordance with.
Much obliged.
Be very careful.
Much obliged.
Imtiaz.
On 6th of October 2023, a coordinate bench of this honorable court was pleased to grant anticipatory bail. But I have twofold submissions. One, my lord, the condition which was imposed, my lord, that he will meet the investigating officer once in a week. That has been violated. One. And second, my lord, I will beseech your lordships to come, my lord, to page 40 and 41, where, my lord, I have addressed a letter, my lord, to the officer in charge, where I have come to know that they have violated the condition. Kindly,
All right.
my lord, the state will be.
I am putting the case. He said that he has violated conditions of it. Huh?
I shall file a report.
So
I pray for the service, my lord, if it could be served on us. For the private opposition.
Has been served, my lord, kindly.
no, give another copy.
Affidavit of service was.
Petitioner is directed
And
to
the charge sheet has already been filed.
hand over a copy. Charge sheet is filed.
Charge sheet is filed, but my lord will kindly
All right.
consider, my lord, if it is.
Petitioner contends that opposite party had not complied with the condition of bail, that is to meet the investigating officer once in a week. Learned lawyer for the state and de facto complaint submit. Charge sheet has been filed. Although we do not appreciate the conduct of the opposite party in not complying with the condition to meet the investigating officer once in a week, but in view of the subsequent development, that is completion of investigation, we find no worthwhile purpose to adjudicate this issue. Worthwhile purpose to cancel the bail on this score.
But my lord, this, my lord, subject to, my lord, correction, my lord, this has happened prior to filing of charge.
We know, but now what is the use of cancelling if investigation is over?
There is a report related to post
Petitioner has assailed ordered granting anticipatory bail on the ground that opposite party has have misused liberty. Report is placed on record. Report shows no contemporaneous complaint alleging misuse of liberty had been received by the police station. Under such circumstances, we find no reason to interfere with the order granting bail. Next.
Okay. But I am for the petitioner.
Why cancel?
My lord, after operating the bail, the accused opposite party, my lord, constant, my lord, threatening the de facto complaint.
We have seen it.
My lord.
We have considered the order granting anticipatory bail has been assailed on the ground that opposite party has been threatening the petitioner and others. We have produced the letter of complaint. The letter is bereft of material particulars with regard to date and time when such threats or threats were held out. Hence, we do not find, hence the allegation of misuse of liberty is vague and non-specific, and no case of interference is made out. Disposed of. Next.
48.
I'm for the petition.
49.
Lordship, paragraph 7, I have stated the reason, Lordship, that for cancellation of bail, Lordship, I'm challenging the order passed by the learned court below while allowing the application of anticipatory bail, Lordship.
Petitioner contends that the judge failed to consider that the victim was assaulted when she was in the family way. We have considered the materials on record, including the impugned order. The impugned order shows that the trial judge had considered relevant materials on record, had produced the case diary and other relevant materials on record. It cannot be said that the order was passed in a cursory or perverse manner. We find no reason to interfere with the impugned order. Next.
I am for the petitioner.
Yes.
On the date of passing order, the accused person has made false submissions before the district judge in his petition. On the date of making petition, he was in bail in a similar case at Kanpur, where he has obtained bail from Honorable High Court of Delhi. Secondly, he was implicated in a criminal proceeding at his hometown Ludhiana. I have also mentioned in paragraph 14 and 21 of the cases in which he was involved.
All the cases are at the behest of the petition.
Where is the order?
79, at page 79, my lord. No.
79 is the
79 is not the order.
91.
91.
This is the petition.
91 is the
Where are
petition.
Ah.
88, my lord.
So he has granted anticipatory bail holding dispute is civil in nature. Let us see your FIR.
FIR has not been annexed.
That is, I think, 78.
Yes.
FIR is 78.
78.
Yes. Another fact your lordships have considered that if the dispute is civil in nature, under the same sections, complaint case filed by them before the Metropolitan Magistrate Court is criminal in nature, cognizance has been taken and proceeding is going on. For the same dispute,
They are not paying you money for sale of the Howrah property.
There are properties of millions spread throughout Bengal, outside Bengal, in Uttar Pradesh, in Delhi, even in Canada.
You have filed opposition.
No, opposition has not.
File opposition. Affidavit in opposition be filed 2 weeks. Reply 1 week. Matter will appear 4 weeks.
Much.
Great.
एक करोड़ का यहाँ पर property. There's a family settlement where you will get 10% of the commercial properties and 12.5% of other. Yes.
Your service, my lord. But the case is under section 498A, 494, 306 of the Indian Penal Code. The de facto complainant's sister was murdered by pouring oil upon her at the matrimonial house. Thereafter, anticipatory bail was granted. And my lord will see that a notice was issued by the police officials to this de facto complainant stating that kindly produce the medical documents showing that the deceased was mentally ill. That was the most surprising thing. To which we have replied on the immediate effect that no, we are not having any such thing and this is a purely false thing. And my lord will be, I was astonished to see that even no condition was given, that witness action has still yet not even started. So they should have resided outside the jurisdiction because they are the influential persons.
Charge sheet filed, my lord.
After
Lord,
filing of
17th
charge sheet, they have
August
been enlarged on
2023, my lord, the
acceptable.
bail was granted, my lord. I am not residing there, my lord.
Well, let them stay at least outside the
Not
jurisdiction of South
residing there.
24 Parganas.
He is saying, I can now South 24 Parganas.
South 24 Parganas, my lord. Well, the
I'm not
witnesses are there,
residing
my
there.
lord.
You are not residing in
No, my
Gosapa?
lord. No, my lord.
Where are you residing?
My lord, I am residing the Taranani Mondol's house, my lord.
Where is Taranani?
Taranani Mondol, Vijayanagar,
Gosapa.
Goshaba.
Then
And my lord, this is Birajnagar colony, Birajnagar. That is Birajnagar, my lord.
These are canning of
My lord,
Goshaba.
from the Aadhaar card, my lord.
both are Vijayanagar.
My lord, the address is, my lord, the Birajnagar colony and Birajnagar.
Both of you stay outside Gosapa.
My lord, I am already, my lord. I am already, my lord.
All right. Order dated 17/8/2023, granting ancillary to the husband and mother-in-law, na?
Yes, madam.
To
My lord,
the
sister-in-law and mother-in-law and sister-in-law.
Three. Sister-in-law, mother-in-law, and the husband.
No, husband
No,
nahi
no,
to.
husband
Husband nahi to.
no, husband is not.
Shanoka Vishwa, Shanoka Vishwa, Shanoka mother-in-law and
Hey, why keep them outside?
Assistant.
Husband is out.
my lord, yes, my lord.
Against opposite party number 2 and 3, that is mother-in-law and sister-in-law of the victim housewife, has been assailed. It is contended that investigation is not being conducted properly, and the investigating agency is trying to portray the victim suffered from mental ailment, deceased suffered from mental ailments. He prays for cancellation of the ancillary bail. And a lawyer for the state and de facto complaint submit that investigation is complete. We have considered the materials on record. Petitioners, opposite party number 2 and 3 are the in-laws of the victim lady. They in-laws of the victim lady. Statements of witnesses show there was quarrel between the victim and her husband. She committed suicide at her parental home. In view of the aforesaid circumstances, we find no reason to interfere with the ancillary bail granted to opposite party number 2 and 3.
Great. Great. But evidence service is kept in the record.
What?
Affidavit service has been filed.
Good. About Switzerland. Switzerland का case है?
Please, Your Lordship. Well, affidavit in reply.
For what?
Cancellation.
What is there for affidavit in reply? UBS Switzerland?
Well, kindly come to page 132 of the Malad application for cancellation.
Which was?
Starts at page 131. Or page 131.
2019 order, my lord. and the consequential order of bail
Well,
were not
I'll
challenged.
get there. Well, I'll get there. Well, I'll get there. Well, kindly come to
Which
page
year?
132.
This year?
Which one, Malak?
You will get there this year.
This year, yes. But I'll tell you why, Malak. This order is passed in 2018, 19. Even till 2024, they have not complied with the condition of your lordship.
What is the condition?
My lord, accordingly, at page
Where is the order?
140.
140.
A4.
No,
Next
first,
study.
my lordship's order.
Yeah, that's the order.
131.
And you are asking us to cancel our order.
No. Kindly see. My no. My
Well, the primary ground is there was a closer report. Then there is a second closer report. Since there was a closer report, the inferential truth is we have not cooperated.
Yes, let me just, my lord.
On that, they want, my lord, the
Kindly
cancellation.
bear with me, my lord. Accordingly, we direct the petitioners to submit necessary documents and/or papers and explain the circumstances in which they came into licit possession of the alleged pledged goods in the meantime. Now, my lord, after this order was passed, my lord, in the middle of the pandemic, the investigating agency filed a closure report saying it's a mistake of law. My lord, we challenged that. Further investigation was, my lord, allowed. After the end of the second round of investigation, filed a report saying no evidence could be gathered. We, my lord, challenged that. And the order that was passed, my lord, will kindly come at page 185. This is the order pertaining to the second narrative. Now, the relevant portion, my lord, is at page 190. Page 190, my lord, last paragraph. The last but 20 and 21.
You got all the money, no?
No. The goods that were embezzled, my lord, is worth 55 crores. The goods that were traced out during investigation, my lord, part of the goods. But after the case got transferred from the local thana to the detective department, my lord, everything changed. In the middle of the pandemic, a final report is filed saying it's a mistake of law. Well, kindly come to page 190. I'll place paragraph 20 and 21. Investigation also lacks any instructions of payment of money for goods made to the off-taker banks, whereby the accused received the bills of lading. There is also incomplete investigation apropos the details of dates on which off-taker banks returned the bill of lading to the complainant, as also to whether any payments were made in relation to the said transaction. My lord, the condition on which my lord had granted them the interim protection was that they will provide all the documents showing licit possession of the goods. This was the observation of the learned magistrate, after which, my lord, we filed.
Where?
At page 190.
190.
My lord. 20 and 21, my lord, at the bottom. My lord, it is only at that stage.
You argued this matter?
Yes, my lord. At that stage, my lord, we got to know that despite my lordship's protection, they have not supplied any document. Then, my lord, comes the best part. They file an affidavit in my lord opposition.
Page 17.
My lord, affidavit in opposition, can you take it up?
Well, why should the bail be cancelled?
No, I am just bringing it to my lordship's attention because my lordship said given them some interim protection relying on that.
What interim protection? They have got bail and the ancillary bail was granted after the money was withdrawn. Subject to compliance of
there are two applications. There was one application for bail.
Which one are you asking for?
For the anticipatory one, because
there's a common order passed.
That I know.
Page 140.
The order that I pointed out. The order I pointed to my lordship, that was in for these two petitioners only. At that point, my lord, the other persons had not been arrested. They were not before your lordships. That order was passed only in respect of these two petitioners, who said that they are going to produce all the documents to the police to show.
Bail or bail is in personam. It cannot be for all.
Just kindly come to page 17 of the affidavit in opposition. Kindly, for a moment. For a moment, 70. I would like to clarify that I have not paid the seller of the above invoices due to a dispute. Some dispute has been filed by a suit by us in the Honorable High Court of Calcutta, suit such and such, which is pending. Well, clearly, when they made the submission before you in 2019, they knew they have not paid for it. They knew they have not paid, that they do not have the documents in their possession to show the licit possession of the goods. They knew it then. They knew it all along. Yet, my lord, they made that submission to persuade your lordships to give them that protection at that relevant time.
We cannot sit in judgment over our.
No, no, man. I am only pointing out to my lord.
You are pointing out, we are responding to that submission. Let us say, you say that this was wrong, but then we cannot review our own
The
order.
thing is, we were not aware of what was collected in the investigation. Because only when we read the order of the learned magistrate, my lord, allowing a second Naraji petition, that we became aware that this has not been complied with.
Heard Mr. Banerjee for the applicant, for the petitioner, Mr. Bhattacharya for opposite party number 2 and 3, and Mr.
But there was a direction of the state to file it.
For state.
We are together, my lord.
But there was a direction on the state.
Public which? And
Public prosecutor perhaps cannot appear. Because, no, he was my leader earlier.
No. Mr. Nondi.
Mr. Nondi was not an officer.
Mr. Nondi for the state. Matter shall appear 2 weeks.
May I just, the report was called from the state.
Nothing is required. We'll
It's the order.
attend. First, let us understand where is the scope for our cancel.
Very well, ma'am.
Other matters tomorrow.
And it's not maintainable as well, my lord.